Hey guys, we're going to move into an analysis of a professional responsibility question, February 2012, question 5. Um, I like this particular exam answer because it gives us a chance to highlight what is probably the best way to structure a professional responsibility question. If you look at different examples, you will see that you can structure the question or structure your answer with the duty itself and then move into the facts, or you can structure your answer by stating the major fact that gave rise to the particular duties that you're going to talk about. I think that that second approach is smart because it kind of headlines the major situation you're going to deal with, which then gives you the chance to plug in specific duties. For example, there was a question dealing with representing multiple clients, and so you might have a heading there that says representing Alan, Bobby, and Chris, multiple clients, and then kick down in that example to duty of loyalty, potential conflicts, actual conflicts, discuss the rules relative to both of those, which are always going to hinge on essentially whether a reasonable lawyer would be able to handle the case, disclosure to the client or notice, and then informed consent. That is essentially going to be your analysis there, come to a conclusion, and in that scenario, again, you definitely would talk about confidentiality. Depending on the situation, you might talk about competence. So in any event, by stating the major fact that gives rise to the duty, it sets you up to talk about things in a complete way. And so in this example, I think it's wise. There's another example that I think you guys should look at because it's a little bit, it talks about some alternative rules that you might not have done a lot of study with. And it's actually July 2009, question 2, dealing with representing a movie actor and dealing with prosecutor special duties, extrajudicial statements. I think that's a good one. So again, July 2009, question 2. Let's come back to February 2012, question 5. This is an interesting question. It doesn't have a whole lot on it. Your main analysis is under the perjury issue and some discussion of expert witness fees. You'll see also referral fee. So what's the situation here? I definitely think you should read through the facts so you can do the analysis yourself. But essentially, we have an attorney who sent out a professional announcement to doctors in the area saying that he was a personal injury attorney and, kind of is saying who he was, his address, etc. What matters here? Well, we're dealing with solicitation. So we state the issue, solicitation. We deal with ABA California, where we cannot have live solicitation to people that we don't already have a prior relationship with. The professional announcement, however, is allowed as long as it gives full information that's accurate, fair, meaning not misleading. California, you can't give guarantees. So what happened here? Is he okay by sending this sort of broad announcement? Yeah, he didn't violate the rules by doing that. So no problem, pretty basic issue. Make sure you come to a conclusion. Thus, he has not violated his ethical duties. Next issue, a bigger issue, paying expert witnesses. Now, the facts in this scenario say that the client was injured by inhaling fumes from a chemical company. And so obviously, in order to prove the case, we need to prove that the chemical company actually caused his sickness. And so an expert witness was required. The key fact here, which goes more to perjury, is whether or not the doctor is perjuring himself by giving an alternative medical hypothesis that runs counter to the scientific literature. And so that is a trigger that will lead us into what the duties are with allowing experts or other witnesses to testify. But in terms of the expert witness fee itself, ABA in California, you're allowed to pay experts for time exerted. The fee needs to be reasonable, and the fee cannot hinge on favorable testimony. So while at the same time, this person is expected, I suppose, to give testimony that's helpful to the case, you can't pay him for that. All right, and that didn't necessarily happen here, so thus no violation of paying expert witness. Allowing the doctor to testify. Now here's where we get into the meat of this analysis. You might want to put the heading perjury. The example answers don't do that. They just get into a thick discussion, but I think it's a good idea, since this is such an important issue, to say perjury. And then ABA and California have slightly different rules with regard to client perjury. Not necessarily witness perjury, but client perjury. And I think it's interesting that they point out that there are distinctions. So what can you learn there? If there are distinctions between ABA and California, point them out, because there's probably an argument you can make. If there's not an argument you can make, you should still point out that there is a distinction and then say, however, in this case, that distinction is not going to be dispositive. And I think that's a good way to say that. What's happening here? Under the ABA, if the attorney knows that the witness is going to perjure themselves, he can't call the witness. All right? California is the same. But if the witness is the client in a criminal case, then the person has a constitutional right to defend themselves, but the attorney can't help the person. So the attorney should persuade the client not to perjure themselves. The attorney should try to withdraw, and if the client decides to do that under the ABA, the attorney may advise the court. But he's got to kind of balance confidentiality versus the duty to the court. That's the ABA analysis. That's the ABA rule. The California rule, same as ABA here, I mentioned that the attorney can't know the person's going to perjure themselves. However, if it is the client in a criminal case, they can give their defense in a narrative fashion. Similar rules here. Client should persuade the client not to testify, try to withdraw. But in California, they're not required. Attorneys are not required to warn the court, and that's the distinction. Why bring that up? Because as a touchstone, you might say here, the witness is the expert, it is not the client, and therefore we don't have to discuss the distinctions between ABA and California law as to this particular case. However, we do need to talk about whether or not the attorney knows the person is going to perjure themselves. Now we get to the major fact that you've got to argue, and it hinges on this. One, the attorney did not know for sure if the doctor was right or wrong about his or her opinion. And the issue becomes down to that scientific studies say that this injury to the attorney's client couldn't have happened from the chemical company, which looks like the doctor's lying. But the argument that a good lawyer would make is that the doctor is giving a clinical opinion based on his own expertise. So can there be conflicts between scientists, conflicts between doctors? Of course, it happens all the time. Science evolves, as a matter of fact, based on different evidence that comes up, different prevailing opinions. And so here, both under ABA and under California, the attorney did not know for sure the witness was going to perjure himself. And so it's not a violation to call the doctor and to let the doctor testify. Thus, there was no violation of the rules regarding client perjury, duty to the court, which flows from this particular major fact. So see the structure, and notice here some deeper arguments. And you can read the sample answers to see how that kind of fleshed out. Two more kind of issues here. Sending the doctor the gift was the major sort of fact. And then from that, we deal with gifts to witnesses generally, and then we deal with referral fees, which the gift to the doctor, I think it was a $500 gift certificate. Let me just double check. That actually, let me see, yeah, a $500 gift certificate wasn't necessarily a payment, but it was a large gift. So what's the rules here? Under the ABA in California, you cannot give gifts to witnesses. You can only pay them for their service. So was he paying him for his service, the expert witness? No, because he already paid him for his service. So the gift is not payment for service. It's a gift. And you want to discuss that. You want to lay that out. Thus, this was a violation. You see how you discuss those facts. Paid him for service here. This is not payment for service. It is, in fact, a gift. Referral fee. Was the gift a referral fee? Well, there's different rules under the ABA in California. Generally, referral fees are not allowed. In California, it is possible to give a referral fee if there's disclosure and consent. And here, there wasn't disclosure to the client, and there wasn't consent by the client, and therefore this would be a violation. Thus, there was a violation. Now remember, it's always a good idea in a full analysis in any subject, but in pro-rep in particular, you might want to, if you have the time, you might want to give a conclusion and say attorney has not violated solicitation or paying expert witness, has not violated the perjury requirement, and has probably violated gifts to doctors and referral fees, just as a conclusion. Do you need it to pass? No. Does it look like a more complete answer? Yes. And that is essentially the analysis for this question. So good luck with this.